Hey everyone, Dan McKenzie here with McKenzie Law Firm. We are an estate planning, estate administration, and small business counsel law firm in the Denver, Colorado area, and wanted to talk today about modifying or updating estate plan documents. This is a question we get a lot here when especially we're doing planning with people and we're asking them to make decisions that are obviously really important, momentous decisions about how you want your kids treated and what you want your legacy to be, and what do we want, how do we want our kids to be able to access money that we might be leaving to them. And obviously these things can really change over time, especially if you're talking about a family that has like a 6-year-old child, and we're asking them, well, how would you want your child treated when they're 40? Do you want them to still have to go to a trustee, or do you, at that point, are they able to get the money without any questions or strings attached? So obviously when you're asking people to make decisions that could play out over decades, they're nervous, and sometimes that causes things to pause a little bit. And so we always try and reassure people, like, look, this is a living document. This plan, you have to think of it not just as something that we're doing today and we're done with it. A lot of people get estate planning done on the checklist. They get the estate planning done, they check it, they think they're done, and maybe they'll revisit it at some point down the road, but they're not really thinking of it as something that's sort of an ongoing thing. But when you really stop and think about it, what you know today is going to be very different than what you know 10 years from now about yourself, about your finances, about your family. Even for people who don't have 6-year-olds but have 46-year-olds. I mean, the difference between where that 46-year-old might be and when they're 56 could be quite different. People in their 40s and 50s, of course, they get divorced. They have family members. They might pick up stepkids. They might get remarried. There's all kinds of stuff that can happen to someone, all the way through their life that would very much affect how you want your estate plan to impact them. And so, again, our advice to our clients is generally like, you need to think of this as here's a snapshot of my opinion now. And obviously we want to do the best we can to try and make a plan that has some longevity to it and that can be relied upon if the worst does come to pass and this plan gets kicked into effect, and it is the plan that ultimately gets used. But at the same time, we want to have the attitude that this is something we're going to keep changing. So on that point, people ask, well, how hard is this to change? And again, I'm trying to reassure clients. One of the things I'm always telling them is, look, these are not contracts, right? These are not things that you are bound by. It feels that way because when you sign estate plan documents, you usually have at least a notary, sometimes witnesses, depending on the document, sometimes both. And so you're sitting there with all these people watching you. You might be making some sort of statement about what you're doing. So it's very formal and has a very specific process that we go through to get these things correctly done. And that process can feel very much like signing a mortgage or signing a car loan or anything else that you do that can be permanently binding and something you can't necessarily just walk away from. But on estate plan, you can, right? You always can change it. As long as you are alive and able to have the capacity to do it, you can keep updating your plan as often as you need to. And you want to kind of keep that to, a reasonable amount, right? If you're, there really are some people who have estate plans that they're updating, couple times a year, and it just gets out of hand. And so those can be really hard estates to administer actually after the person passes away, because there's so many versions of this thing out there, and there can be fights about which one was legitimately executed or not. But setting those people aside, usually it's pretty easy to do. And the rule of thumb on this is just that you need to observe the same formalities as far as signing these documents and signing their amendments as you did the first time you did them. So when you do a will, generally the best practice on signing a will is to have a couple of disinterested witnesses, 2 people who have nothing to do with the plan, they don't benefit from the plan, they're not family members, and a notary. Actually, if you read the statute, the bar is lower than that. The witnesses could conceivably be interested, and you might not need a notary, or you might just need a notary and not the witnesses. But like I say, best practice to have them both. And what we And other attorneys see sometimes is people have estate plans, they do that with the will, and then they want to change it. And so they go in and they just cross out and kind of amend whatever they want to do, and they initial it, right? Like it's just, you know, I don't know, some sort of, I don't need, you know, maybe a contract or something like that. You could do that with the other person's acknowledgement, but on a will, you have to follow the same formalities, right, as you did when you executed it. So if you needed witnesses, if you needed a notary to watch you sign this thing to actually have it be valid, well, the same is true of amendments. We don't want a situation where someone goes through all these steps to get a valid will in place, but then it can just be changed by, you know, they're sitting in their living room and they're crossing things out and changing things. That obviously causes a lot of problems as far as what people think might be valid. So if you're going to amend a will, there's a pretty high bar. Other documents like powers of attorney, a trust, living will, they all have slightly different levels of formality that are required. So like your medical power of attorney really doesn't even need to be notarized, actually. We usually do that just to make sure it's very clear that it was intentional, but that very low bar on that. A trust usually is notarized. In some states it does need to be witnessed to. Your living will is supposed to be witnessed by a couple people. And so just different documents have different steps that you need to take to have them validly executed. And it's, again, same thing on amendment. But if you're listening to this and thinking through, well, none of that's real hard. I mean, it's not real hard to get two witnesses, actually. It's not real hard to get a notary. I mean, they're everywhere. So you should not be intimidated by that or feel like, oof, I better put this off until I have perfect information about my family, right? I got to wait until I see how this 6-year-old turns out to really make a plan here. And I don't think people think of it like that, quite that explicitly, but kind of in their heads, they're thinking, well, you know, there's just so much I don't know right now. I'm gonna put this on pause for the moment, and that's a bad idea. For obvious reasons, that is a bad idea. We just don't know when the plan's actually going to be needed. So putting it off until you get to this state of perfect information that will never happen is obviously going to cause some problems. So you know, get the plan in place with what you know today. Do the best you can with the information you have, and just understand that as you go down the road, as your family ages, as things change, I mean, things are gonna change. Things are gonna change. So don't let that put this off for you. Like I say, it's easy to amend, but not if you're thinking of amending your plan. It's not so easy that you just, again, can cross things out in at your kitchen table and amend things. You do have to take certain steps to do it. They're not hard, but there are certain steps you have to do. So those are my thoughts on amending an estate plan. And if you want to have a discussion about that or anything else, estate plan or state administration related, we're here to have that conversation with you. If you're in the Colorado area or have some connection to Colorado, our phone number is 303-578-2745. And again, we are the McKenzie Law Firm. Thanks for watching. Hope this was helpful.